Welcome to the Business SOS podcast. This is Rich Sierra with the Florida Small Business Legal Center. This is episode 137 of our Business SOS podcast. Thank you for listening, supporting me for the last 2.5 years. So last week we began the series of buying a business, and where we left off, we were talking about the importance of due diligence and how that process should not be shortcutted or should not be uh, skipped. And when I see in my practice that when I see deals that don't go well or end up in litigation, which is a big part of my practice, some of the mistakes that I see is that the buyer did not conduct the proper due diligence or conducted no due diligence at all. In some cases, the due diligence was done improperly. Questions were not asked, and it was just not reviewed properly, and in a sense that some of the information was not given to the buyer, which led the buyer to make the wrong financial decision in buying that business. Or in some cases, as I mentioned before, there was too much reliance on the seller's representations and assurances that led the buyer to believe the information without verifying it. And when the buyer steps into this business and looks under the hood, so to speak, find out that the information that was given to him was not accurate. And that inevitably leads to a legal dispute. So, to recap what I mentioned last week, if you're going to buy a business, my recommendation is to get a CPA to help you and get also an attorney who has done this before, who is familiar with buying and selling businesses to help you with the due diligence process. It's a big financial decision to make, and my recommendation to always have professionals helping you on your side, your team, to help you guide you through the process. It's not something that should be done alone. So I want to talk about a little bit difference between the asset purchase and the stock purchase. They're both correct. There's nothing improper about doing either of them or incorrect about doing either of them. It depends what the goals are of the buyer in terms of buying the assets or buying the stock. So an asset purchase is exactly what it means. You have a corporation in some cases, ABC Inc., and then the business runs through a DBA. And say it's a restaurant business, and you want to buy the assets of the business. What you buy is the inventory, you buy the goodwill of that business. Everything on that business becomes yours when you buy the assets, okay? The equipment, the lease is transferred to you, okay? The business license transferred to you. So you're running that business now as it's your own. What you do not buy is the entity. You don't buy ABC Inc., but that's owned by a stock. The owners have stock. So that's the asset purchase. You transfer that in an asset purchase agreement. There's some of the documents that are prepared as well. But the entity still belongs to the owner. Then the owner does whatever the owner has to do to dissolve the company, wind it down, but then the funds goes to the company. They don't go to the individual shareholder. So that's one example. The asset purchase is a very simple example, but I just want to give you that in context. Now, a stock purchase that is different is that you are stepping into the shoes of that shareholder. So say you want to buy this restaurant, but you want to take the entity. You want to buy everything. And usually it's done, very commonly it's done when people are they needed to apply for an H-1B visa. And hopefully I'm doing the correct visa under immigration. But the visa, the investor visa, you go in and you need a business with payroll in order to qualify for some immigration status. So they need an entity in this case. So the purchase, it is a stock purchase in order to acquire everything, the ownership of that business, everything goes with it. There's some pros and cons to do that. The advantage is if somebody steps in and wants the entity is that you already have the ownership. You don't have to start a brand new company. It's already established. The opposite to that is that when you step in, you take all potential liability that comes with it. As opposed to an asset purchase, you don't take any liability from ABC Inc. That's the new owner, that's the old owner, that's their responsibility. You're only taking out, separating the assets beyond yours. The entity belongs to the owner. In a stock purchase, you become the owner. So if there's any potential latent claims that have not been raised that come in later against the company, you have to respond for them to those. You have to respond to those claims because now you become the owner of the new company because now you own the stock. The funds in this case, the funds to buy the business go directly to the shareholder who's selling you his stock. It's just a little different, okay? Likewise, in a membership transfer agreement or a membership sale, in a case of an LLC, the funds go to the member of the LLC. So it's the same as a stock shareholder, but it's a member. So that is the distinction here. And then you become the owner of the LLC versus only taking the assets. That could be a separate discussion regarding the advantages of doing the stock purchase, the asset purchase. Maybe we'll bring a CPA here to help us at some point in terms of potential tax liability for both, et cetera, or advantages. We'll bring a CPA to help us with that. But just to kind of, for the context of this conversation, I wanted you to understand the difference between a stock purchase and an asset purchase. Most of the transactions we do are asset purchases. We're dealing with a stock purchase. The due diligence is a little bit deeper because you want to go back 5, 7 years. In terms of, especially with taxes, you definitely want a CPA looking at those tax returns because you want to make sure that everything is perfect there and that you don't have a potential claim for unpaid payroll taxes for 5 years ago. Or you don't want anything that comes to you with respect to something that was not disclosed, or even the owner did not know. Because in Florida, you have 5-year statute of limitations for contract claims, and you have 4 years for most of their claims. So if somebody fell in the premises, that reported, say, 3 years ago, okay, the owner may not know. So you want to make sure that you're protected, and an attorney can help you create certain buffers, so to speak, to protect you in the case something comes out after the fact, after you buy, to reduce your potential liability. That's more of a risk management issue, but that's why you want an attorney helping you with this, not do it on your own, especially if it's stock purchase, because they're stepping into the shoes of that owner. And it's very common to have stock purchases, say you have a partners, and we'll talk about this segment as well, about bringing somebody into the company. So you have a partner wants to buy the other partner because they're already, one partner is retiring, they're moving. So there you would have a stock purchase agreement, a stock transfer agreement. Usually due diligence is not to be as extensive because the partner's been working in the business already. The partner knows the business. Or if you have a key employee who has been the manager of that business for a number of years, the manager knows the business inside and out, and then he wants to, the owner say, you know what, I'll sell you my stock, you take over the business, they work out some type of transaction. It could be a financing transaction or a cash transaction, and then that occurs. And so the due diligence there will not be as extensive because the person has access to everything. It becomes an issue when you have somebody coming in, buying the stock that doesn't know anything about the business, So due diligence has to be more extensive because you want to double check everything, especially with stock purchase, because you step into the shoes and you want to make sure you what you're stepping into. I want to talk about warranties, representation warranties, and indemnification. Yeah. So we get to the LOI. We get past the LOI stage. We conducted due diligence, uh, and you're satisfied with the due diligence. Everything looks good. You check everything checked off. Uh, if there's any adjustments that were made, you negotiate it at maybe a different price. Not much. It's basically common to negotiate a price based on some things that you saw in the due diligence that is found in the due diligence investigation. But now you're ready to go for the purchase agreement. So the purchase agreement is more involved. It includes everything that you have on the LOI, but then you have warranties and representations that are included as part of that purchase agreement. You're not going to focus on the asset purchase agreement in this case. Although in the stock purchase agreement, you still have the warranties and reps section as well. And in that one, there you update whatever pricing you want to have for the purchase of the business. If there's any type of contingency for financing, it is updated there as well. If there's a closing date, it's also modified or changed. Whatever updates need to be made regarding the transaction, it is done in the asset purchase agreement. Because at that point, when you sign that document, the LOI goes away. Okay, there's no longer an LOI because you have a new document to the merger clause. Any past agreements or representations, whether oral or written, are merged into this new document. Everything kind of transfers to the purchase agreement. So, and there's a section there that the seller makes warranties and representations. And one of them, there are several of them, okay? But you look at the seller makes representation that the financial statements provided to you are accurate, that the person owns the assets that they're transferring. That's very important. That they have disclosed all liabilities that they know in that business. That they have complied with all laws, rules, and regulations, and that they have all the contracts that they have are in good standing, and also that the customers, that the status of the business, especially with customers, is still current as of the date of the LOI. That there's no material change in that business for the time that you express interest and the time that you put a deposit for the with the letter of intent to the time that you're about to close. And those warranties and reps continue to they travel. It's not just at the date of signing, because you might sign the purchase agreement at a certain point, and then the closing might be a little bit later. And I'll give you an example. Okay, say you're buying a commercial pool cleaning company, and they are primarily work with commercial clients, say large homeowners associations like we have here in South Florida or the state, and they have, say, 15 or 20 clients, but 80% of the revenue comes from 2 clients. By that time, you should know that. I know a lot of times people don't want to disclose their clients, and there's a way to provide that information without disclosing clients, but at a certain point, you need to know who they are. Say, for example, prior to closing, one of those big clients decided to cancel, the account was dropped. Okay? That's going to be a significant loss in revenue for that business. So in that case, you close. This happened before. You close in the business, and that's not disclosed to you as the buyer. You start going to the various accounts, then you find the letter after the fact that says, hey, you know, the contract has been canceled. We switch vendors. And that revenue that you relied upon in this business and you were represented, the revenue was coming in for a large account is no longer there. That is important to know. So that is a material misrepresentation or material omission. That's why I like to have deals that have some financing involved from the seller. Doesn't have to be a lot, but some of it. Because you also have the seller usually stays in the business for say 2 weeks or 1 month for transition and training. But if there's money that is owed to the seller for say 24 months as part of the transaction after the first the amount of money is pre-given to them at closing, the seller has the vested interest to make sure that you do well, those accounts remain current. The seller knows that if that revenue drops, most likely they're going to say, you did not disclose this to me. We're not going to pay the second half. We're not going to pay the financing. We're going to sue you for breach of contract. So it's important to know how the revenue is generated to that business, and the revenue breakdown is important. Not looking at the sales in total. And the tax returns will give you a sales in total, but will not give you how those sales were generated in a monthly basis, and will not tell you what percentage of that revenue came from whom. Came from, the revenue spread. Did it come from 10 clients, 15 clients? Is the average sale came in from, if you drop 1 or 2 clients drop, is that going to be a significant drop on the clients on the business, or it's going to be generated by one huge client or two? So you have to understand that before buying that business. The seller does not want to disclose that to you. That's a red flag. So it's important to know that. And that's part of the warranties or representations that are made, including litigation activity, including threat of litigation. And that's part of why an attorney is essential, I think, in this case, to help you with that. Now, something that is going to come up in these types of transactions is that how long will the seller have for a non-compete? Meaning that how long will the seller agree not to compete with that business? What I recommend in those cases is to have a separate non-compete agreement. And I have had litigations on that before, in which the seller agrees not to contact those clients. Number 2, not to poach employees. Number 3, not to engage in the same or similar type of business directly or indirectly that compete in a specific area that will compete with that business. The non-compete has to be reasonable in scope and geographic limitation. But a separate non-compete agreement is important to have. What number of years, how long the non-compete should be, that's subjective. That's up to the type of business you have, the impact that this seller would have in contacting those business, and how long. You could have 3, 5 years for selling in a business. 5 years is reasonable. But that's subjective. You and your attorney should discuss what type of non-compete you want to require, and what they're willing to sign. And non-compete agreement is a separate issue in of itself, and drafting those agreements. So that's a separate podcast. But you definitely want to have an attorney help you with drafting the agreement and putting in place the various provisions that allow you to enforce that agreement properly. So that's very important. So that's not something you want to just put in the purchase agreement. You'll mention it there, but you also want to have a separate non-compete agreement to protect you from the seller wanting to compete or directly or indirectly the business. And that means assisting somebody else to do the same business or sharing the client list. I can tell you stories. Okay, but you get my point that that is very important. Um, Deals that I do not like that has happened before, okay, is that they agree to what I call earnouts. That they pay a purchase price, okay, and then they agree that they will pay a certain amount more if the business earns a certain amount of revenue into the future. And I've seen structures like that before, and inevitably, in most cases, just does not work. Okay, uh, simply because they're going to say, you know, you did not run the business the way you're supposed to run it. You still owe me the money. The seller says, I'm entitled to the money because you did not run the business. You're going to say, well, I did not earn the amount of revenue that I was expecting, so I don't owe you the money. So anytime you have a clause into the future about the performance of the business, it's such an uncertainty that, in many cases, it's just not work out. So it's not something that I like and recommend because it leaves kind of an intangible out there, an uncertainty, a cloud of something that it could go wrong. So when I do my deals, I like them clean. There's a closing, and from this point forward, the buyer owns the business, the seller is out. There'll be a financing point, but that's a financing is done through a separate promissory note, and then that's paid over time. That is fine. But there's no question about the ownership of that business. Uh, and there's no question, there's nothing that is required for that business for them to trigger another payment, with the exception of the promissory note. So, in terms of future performances, it's not something that I recommend for obvious reasons. You cannot predict the future. Um, I've had disagreements regarding transitional support. Uh, you know, it's it's good to have the seller provide support and provide transition in reference to the operations, but at some point you got to run that on your own. So do what you can, make the transition, but that's usually not a subject of litigation in most cases. If the business owner seller helps, then it's available via phone or email or text, and then the owner decides, takes over. So I don't see a lot of litigation coming from that. Now, I want to talk a few minutes about adding partners. And there are many reasons why to add a partner into your business. Could be you want additional capital, you want to expand the company. In this case, say you want to buy into a business as a partner. You want to bring expertise, you want to add a different product line. There are a number of reasons why, and they're all okay. There might be succession planning. You have a business and you want to bring somebody else that is younger as a partner to take over the practice. I've seen that with medical practices, dental practices, be a law firm, for example, as well. They want to bring somebody in younger, so, put in 10 years, then you're out, the new person takes over. So it could be a number of reasons as well. Um, Whatever you do, it is important. You got to treat it as if you're buying a business. And I've seen this before that people enter into partnerships informally. People know each other. They're familiar with each other. Happens with the holidays a lot. And then they, you know, transfer the money first, ask for the documents later. And it should be the other way around. First thing you got to do if you're looking to be part of a business that is already existing, you got to treat it just the same way. The LOI, you got to ask for the operating agreement or the bylaws, okay, to make sure that you are able to go in and be part of this business. And if they don't want to give you that information, that is a huge red flag. If they do not have one, a partnership disputes, bylaws, or operating agreement, there are different names for the document that the partners have, then it's also a red flag. Because that means you really do not know what rights do you have with that business, what you're buying into, how that business really is being run. But I've seen that before. I also want to do another caveat. Whatever document you prepare, it must be in English. I understand that people have the native languages. I see that in Spanish and languages. People go into partnerships and they prepare partnership documents in different languages other than English. It's fine to understand it. You want to have some key points, it's okay. At the end of the day, you want to have the document properly executed in English. Reason why, if you're going to enforce a document in Florida courts or any courts in the jurisdiction, the document has to be in English. Otherwise, yes, the document can be enforced, but you need to have a certified translator to translate the document from whatever language you have into English. So it's an extra expense. It's also another hurdle to cross. Now, certified translator will do a great job in translating the document. The translator is not going to get the nuances of what was the intent of the partnership with the translation. And I've seen that. I've seen documents fluent in Spanish, seen documents in Spanish, I read it, I read the translation. It's not quite exactly the same. But what goes in court is the English translation. So keep that in mind. It's important to do that. If you're going to buy into the company, you also want to interview the partner. You want to treat it just like buying a business, no exceptions. Okay, you want to look at the documents, financials that I mentioned in the last episode, because you are basically taking some responsibility and potential liability in that business as a new partner. And you want to make sure that you're stepping into the business properly, and the money that you're about to invest are going to be utilized properly. And I've mentioned that I've had, and I make this available, my operating agreement questionnaire, which is questions that I ask that are designed to have the potential partners talk about and have conversations about. And that becomes the basis of developing the operating agreement. And if you cannot get through those conversations, then you're not going to draft an agreement. And formalities in this case will not help you. What will help you is having the proper documents. And again, I've seen this before, that people send the money first and then ask for the documents later. Oh, we're getting them ready. Here's the draft. Here's my wire transfer instructions. Go ahead and wire me $100,000 so we can get started. No, that's not the way it is done. You absolutely want to make sure that you have the proper documents drafted and signed before you transfer any money to a brand new partnership. There will not be, the motivation is not going to be there once you give the money. And it seems like common sense. But the reality is, happens all the time. And when the new person, the buyer of this partnership, doesn't get the agreements or gets agreements and drafts, and then never gets an agreement, and then find out the money was used for something else, not for the business, not getting any revenues, any dividends, then that's when I get the call. That could have been avoided. And in most cases, this is when it's done, people that they know each other. Because familiarity. You don't want to offend somebody by saying, hey, let's get an attorney, let's get this drafted properly. No, listen, if somebody's going to get $100,000 from you, it's okay if they get offended. If you ask them, I want to get this document signed. If they're that offended, then perhaps that partnership is not good for you. So you got to protect yourself and use common sense. You want to get a partnership, you want to buy into a business, go ahead and get the document signed. The other hand as well, if you're the one bringing somebody into your business, it is into your best interest to have those documents properly signed and make sure the expectations are met before you accept any money from anybody. It just keeps things clear. It keeps things, it avoids a lot of mistakes and will certainly avoid litigation. If you cannot get through the paperwork or before going to a partnership, that partnership is not going to work for the most part. So I cannot emphasize enough. Get the documents ready. Do your due diligence before you bring a partner into your business. And we talked last week about the deadlocks, what happened with deadlocks and partnerships and the mistakes. But I cannot emphasize enough that if you're going to buy into a business, into a partnership, treat it just like you're buying into a business, because you are buying into a business. And it's also make sure that the landlord of that building also knows. Leave you with this last point. I have situations where a partner comes in, they buys into a business, sends the money, but the landlord is not notified. In most commercial leases, you have provisions that state if you bring a partner anything over 10%, you have to notify us. Otherwise, it's a violation of the lease. It's very important because say you buy into this business, something happens, your partner locks you out of the business, which has happened. You want to go to the landlord and say, hey, I'm a partner in this business, I need a key. Landlord will tell you, who are you? I did not know that you bought into this business. You're not in the lease, you're not getting a key, and they violated the lease. So all these situations have happened. So I'm not sharing this with you as a theoretical example that actually I've faced in my 21 years of practice. So I hope this information was helpful to you. I'll leave you with this. I thank you again for listening. Hope that you got something out of this. And if you have any questions about any topics that I covered in this podcast or any other podcasts that I share with you, please, my email is rich@richsierra.com. Again, it's rich, R-I-C-H, @richsierra.com. My phone number is 866-842-5202. If you have any legal questions or you have any legal issues you'd like to discuss with us, my website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal, as well as Instagram. If you want to watch the video of this podcast, we're at youtube.com/@RichardSierra. You want to check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can also ask for any local bookstores. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.